Good afternoon, everyone. Welcome to the Children and Family Affairs Subcommittee. Thank you for joining us today. And if you all would stand and remain standing for the pledge, Representative Gann is going to lead us in prayer.
Let's pray. Heavenly Father, thank you for this awesome responsibility and privilege that you give us as legislators to come before citizens and represent our districts in this state. Give us wisdom, discernment, and just give us patience as we all go through this process through the end of session. And pray for each family that's represented in this room today, Lord. I pray a special blessing on these families that are represented here, dear Lord, and just go before us, lead, guide, and direct us in all that we do. In Jesus' name we pray. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Secretary, would you please call the roll?
Representatives Bricken, Farmer, Gant, Garrett, Harris, Jernigan, Powell, Stevens, Chair Lady Littleton.
Here.
Madam Chair, you have a quorum.
Thank you. Members, do we have any personal orders today? Members, any personal orders today? Seeing none? So we're going to begin the calendar. This is our adoption calendar that we've worked on for probably well over a year, and we think we have some good things coming before us, so we're looking forward to it. And since we have so many bills on the calendar, we are going to our testimony is going to be held to 2 minutes, and then we'll open it up for questions. So we're going to get started and call oh, no, let me start, do a little housekeeping. House Bill 1032 and House Bill 630 are going to be rolled 1 week. So first we have House Bill 318 by Representative Rutter.
Motion.
Properly motion and second. Representative Rutter, you are recognized.
Thank you, committee and chair lady. This is the one of the best bills you're going to hear today. I know you're going to agree with me
I
before we get through
think
with
you have an
it.
amendment too, please.
I don't have an amendment code. I got a second.
I think it's amendment 3704.
Okay.
I think it makes
I think
it.
I know what the
Okay.
amendment is.
All right, so
So can
Motion-
you just go ahead and put it on the bill?
yes, properly motion and second. All those in favor of amendment 3704 going on to House Bill 318, say aye. Aye. Those opposed, no. The ayes have it. You are recognized on 318 as amended.
Thank you. Thank you. Today, of course, is the adoption calendar, so we're going to be talking about adoption and foster care. As we know, there's several facets to foster care and our adoption system that can be improved to be more user-friendly, child-centered, and outcome-focused. This bill seeks to improvement in two of the primary categories. They are the adoption process and foster care. This legislation seeks to make the process more user-friendly, efficient, and attractive as an alternative to abortion for unclaimed pregnancies. So I'm going to talk with you about a few things, and I'm just going to be short and sweet. Less is more. This bill allows for the surrender process to begin prior to the birth of the child, with reaffirmation required at birth. Number two, it allows for women choosing adoption to receive pregnancy care supports for the duration of their pregnancy, rather than waiting until the third trimester. This bill would allow for a virtual surrender hearing so that the new mom isn't forced to attend court in person in the days following the birth. It allows for a judicial waiver on speed of adoption, finalization from 6 months to 3 months if the court sees fit. This bill also codifies a period of respite for foster families who need to take a temporary break from providing foster care. So I will stand ready for questions.
Thank you very much for this bill and for your testimony on the bill. So we do appreciate it, and it is very important.
It
So,
is.
yes. So
To get these babies adopted sooner rather than later.
that's right. And this just makes the process
streamlines
easier.
the process.
It does. It does. So are there any questions for Representative Rutter? Chairman Farmer?
This is more of a comment, and as I understand it, this bill also extends care for mothers from I guess right now it's in the third trimester, as you mentioned,
Right.
mental health, whatever they need, right? And this extends that, opens that up from
For the
early on.
duration- For the duration of the pregnancy.
That's great. So that leads to a healthier birth potentially.
Yes, yes.
And then also this also provides for health care of that child of the child, right? Once
Yes.
the child's born, does that extend that care as well?
Yes, does it extend the health care of the child beyond the,
I'm sorry.
Yeah.
The mother's
The
potential
mother.
for treatment and care for after birth care.
Yes.
I guess what I'm saying. So
if that's, yes, it does.
that's the way I understood it.
Yes,
So
it
I
does.
think it's a great bill.
Yeah.
Appreciate you bringing it.
Representative Brigham?
Thank you, Madam Chairman. Quick question. Who's going to administer this? Is this DCS or Health Department for?
You have
Representative
private,
Rutter.
excuse me, you have private organizations that handle adoptions, as well as DCS. So they would be handling, this would apply to all adoptions.
Understand,
Representative Rickard.
thank you, Madam Chairman. The healthcare question, I mean, that sounds like it falls under Department of Health or DCS. I mean, to oversee that the mother is getting the right level of health care throughout the pregnancy.
Well,
Representative Brickett, would you like to go out of session and let legal answer that for you?
Sure.
Okay, so we're going to go out of session and hear from legal.
My understanding from the amendment is that this would extend the time that the adoptive parents could pay for services for the birth mother, so they would be paid for by the adoptive parents.
right.
Any other questions for legal? Representative Garrett, you're recognized.
Thank you. This isn't, I think, on the topic, but since we're asking legal, I've got a question regarding Section 3 of the bill, which talks about the surrender being in chambers or through a virtual video platform. I was curious, can you let me know, is this, when it says may, that's permissive, that means the judge can make a discretionary decision on whether or not it's going to be in chambers anyway. I was curious, what under this current statute, do they have to be in chambers? Does the mother surrendering the baby have to be in court?
Yes, the current statute requires it to be made in chambers.
Okay. And then this is making the judge, under the word may, he or she either requires it to be in chambers or can do it over a virtual platform.
Right. My understanding is this would be permissive based on that use of the word may.
Representative Garrett.
Thank you.
Any more questions for legal? Hearing none, we'll go back into session. Are there any more questions for Representative Rutter? Seeing none, are we ready to vote? All those in favor of moving House Bill 318 out to civil full, say aye. Those opposed, no. The ayes have it. You move out to civil full. Thank you very much.
Chair Lady and committee members.
Next, we have House Bill 759 by Representative Eldridge, who used to be a part of our committee. So welcome back, even if it is just
I got
for a
carried away and seconded Representative Rutter's.
We do that when we're out there, don't we?
So,
Properly motion and second. You are recognized on 759.
759 does have an amendment with it as well. Its drafting code is 4851.
Properly motion and second. You're recognized as amended.
Okay. This amendment, what it's doing, it's hoping to.
Oh, we need to vote on the
You-
amendment,
yeah,
I'm sorry.
thank you.
Okay,
Thank
all those in favor of putting Amendment 4851 onto House Bill 759, say aye. Aye. Those opposed, no. You're recognized on House Bill 759 as amended.
Thank you, Chair Laney. This amendment requires the Department of Children's Services to employ at least one attorney in each of their DCS districts, of which there are 12. The primary role is to file termination of parental rights of children in the custody of DCS where it is deemed appropriate to do so. When a child's been placed into custody, for at least 6 months, the department will conduct a review to determine if termination of parental rights needs to be filed, and if so, they would have 60 days following that determination in order to get it in process. So that's what the bill as amended does, and currently. And I think there's some folks here from DCS if there's any questions beyond what I can answer, but currently in DCS, there's 6,000 children that this would probably affect and hopefully get them placed into a more permanent situation, a more stable environment. So that's the purpose of this bill. So I stand for questions.
Thank you for bringing this bill. I try not to say this too much, but every child deserves a good home, so
They
thank
do,
you for bringing
absolutely.
this. So, are there any questions for Representative Eldridge? Seeing none, we're going to go out of session and call up a guest speaker. Connie Regula, would you please come forward and introduce yourself and who you're with? We're out of session. You may. And you have 2 minutes.
Okay, thank you. Well, I marked up my speech, as you can see, so hopefully I can make that in 2 minutes. And I do have a question. Okay. Well, it's red. Is that on? Okay. And I've heard something different as to what was published, which is that they would hire a guardian ad litem for termination of parental rights. So is the guardian ad litem part out of it? May I ask that question on the amendment?
You need to recognize yourself first, please.
Sure.
And who
Yes,
you're with.
Connie Regulate,
Okay, so there is an amendment on it.
which takes out the guardian ad litem provision.
It changes it to a parental rights, a termination of parental rights attorney.
Okay. All right, I will I opposed the bill, and originally, and as it was published, of course, it was to hire guardian ad litems for termination of parental rights, which I think would be an inherent conflict of interest. However, I do want to continue to make some comments. Tennessee already has multiple attorneys in place to file petitions for termination of parental rights. It is an adversarial proceeding, and they're already staffed to do this. The public policy of DCS, as it was created, is for family reunification, and this seems to have been supplanted with an aggressive litigation strategy to sever the relationship between the child and the family forever. Multiple organizations, including the American Bar Association, universities such as U of Chicago and U of Michigan, policy centers such as the National Council of State Legislators, and state legislatures such as Texas and Illinois, have taken steps to redirect child welfare to prevention instead of policing. I urge you to take a step back and look at the policy briefs on these issues and hold public hearings on the societal effects of DCS practices. What we know is that 1 out of 5 children in Tennessee live in poverty, and we know that about a third of the children are removed from parents involving some level of substance abuse. How much better would it be in Tennessee if we built stronger families instead of social engineering families that the government believes is better? Foster care is a government
I'm
program.
sorry, your 2 minutes.
My 2 minutes are up? Okay, I do have, and I prepared for everybody, and I will deliver it to your office, about 50 pages of current policy that you can either download or you can pull directly from the website. I appreciate it.
Are there any questions for Ms. Regula? Seeing none, thank you very much. So we're going to go back into session. Are there any questions for Representative Eldridge? Vice Chair Jernigan, you are recognized.
Thank you. Representative, I notice it's a pretty large fiscal note on this. Is this something that the Department of Children's Services is ready to absorb? Is it part of their,
Representative Leach.
of their
I
budget?
think you would probably have to ask them. I think that the purpose of this bill is to help get children into a stable environment a little bit quicker. I think that with everything else that we do here, I think the best thing we can do here is to look at is the benefits of moving a child to a stable environment. And I heard about, I guess, restructuring of families and everything from the speaker here. I am a parent of a daughter that we had to terminate parental rights from her mother. She is a family member. It was a long, drawn-out, lengthy process. And so speaking from a little bit of experience, I think that the quicker you can get a child, and I think that what I would hopefully rely on is that DCS and that attorney would take a good solid look at the situation that child is living in. Because my daughter was living in a horrible position, in conditions that probably the dog that was in here earlier has a better lifestyle than she had. So I think if we are going to do anything to help children, and I know this will go to finance, and I know where it will probably be, but I hope that with the money that is available to this state right now, that this would be something we'd take a good, solid look at. Okay. And every family, I don't want to get long-winded on this, but you know, when we had to do something like this, it was hard on us because we had to go against another family member. And that, you know, there's a quality about a family. Just because you can have a child doesn't mean that you're going to be a good parent or be good to that child. So I'll be quiet at that point, and I appreciate your consideration.
Yeah. Thank you. And I wasn't questioning your bill. I mean, it's a fine bill. I'm going to vote for it. But I was just kind of wondering where the posture was with DCS and the money. If it was,
I know that it's being worked on as far as trying to get the funding in place for that. I don't know where it will be.
Okay.
But I know that is going to be a huge push.
Okay. Thank you.
Any other questions? Representative Garrett.
Thank you, Madam Chair. I would just say that for the purposes of the bill says one additional attorney. I assume they don't have attorneys now that do this, right?
Representative.
They do, but I think with their caseloads and everything, and you might want to call up somebody from DCS to let them answer that question if you'd like. I think they would be better prepared to do that than I would.
I don't think that's necessary because my comment to that is we got to be sure who's the client, right?
Right.
Is it DCS or is it the child when they represent, and it should be the child.
And
so that's why I want to make sure we have.
And I think the language it was correct that it was going to be a conflict of interest with the guardian ad litem. So, but the care of the child and the placement of the child should be the primary.
Right.
Yeah.
And I wholeheartedly disagree with that conflict of interest, by the way. I mean, as a practicing lawyer, that's not going to be a conflict of interest, but there needs to be making sure who the client is.
That's
right?
correct.
So thank you very much.
That's correct.
Yeah.
Any other questions? Seeing none, are we ready to vote? All those in favor of House Bill 759 moving out to civil full, say aye. Aye. Those opposed, no. The ayes have it. You move out to civil full.
Thank you, Chair Lady and
It's good to have you
committee.
back in here again. It's good to be back. So next, we have number 4 on your calendar, House Bill 855 by Representative Leatherwood. Properly motioned and seconded. Representative Leatherwood, you are recognized.
Thank you. House Bill 855,
There you go.
House Bill 855, this language was brought to me by the Tennessee Bar Association, the adoption section. And this is a cleanup bill for Titles 36 and 37. It makes various technical changes to the adoption statutes. For example, it ensures the code is more clear for attorneys when applying it in their daily practices. It changes 10 days for something having to be done to 10 working days. So just clarifying that and letting these attorneys have their weekends, I guess. It does other things. One section regarding just brutality, abuse, neglect of a child. Currently, it says there have to be experts, plural, to identify that, and it's changed to qualified expert. So just making it a single expert can establish that. Other aspects of it, the current law establishes a putative father registry. That's what it's all about. And it just changes references within those sections where it says, you know, those persons or person, and just changes it to be more reflective of what the registry is about, changes those terms to putative father. So it's just a variety of cleanup things like that. One aspect that might be a little more substantive, sections of our code regarding severe sexual child abuse and trafficking for commercial sex, you know, violations of those Tennessee laws, the courts are allowed to take that into consideration. This bill would also say that laws of another state that are substantially similar to our laws regarding these offenses could be taken into consideration by our courts. So in other words, if this happened in Arkansas, and Arkansas would define that particular abuse very similarly to what we would, then the courts could take that into account. So with that, I will take any questions or defer questions, and I appreciate y'all's support.
Questions for Representative Leatherwood? Seeing none, are we ready to vote? All those in favor, question's been called. All those in favor of House Bill 855 moving out to civil full, say aye. Aye. Those opposed, no. The ayes have it. You move out to civil full. So next we have Representative Leatherwood with House Bill 854.
Okay. Similarly, this bill...
We got to get you in proper
I'm sorry.
posture. Properly motioned in second, and I think you have an amendment?
Yes, 5005.
Properly motioned, properly second. We ready to vote to put Amendment 5005 onto House Bill 854? All those in favor say aye. Aye. Those no. The ayes have it. You are recognized on 854 as amended.
Okay, and the amendment does make the bill, and similar to the last one, this language was brought to me by the Tennessee Bar Association, the adoption section, and this makes a few changes, again, in the adoption hearing waiting period, just some common sense changes. If the child has already resided in the home of a petitioner for 6 months, then the court would have the flexibility, if they're satisfied that the adoption will be in the best interest of the child, to waive the 6-month waiting period after the filing of the adoption petition. So in other words, the 6 months that the child has already been in the home would count towards the 6-month waiting period, so you wouldn't end up having a year. Again, the courts don't have to do this. They look at all the aspects of the case. It just gives them the flexibility to make that determination. Another aspect it does, it gives the courts flexibility if a child is about to turn 18, that if they would turn 18 within that 6-month period, they can waive that time so that the adoption could be completed while the child is a minor, so you don't suddenly go to a whole different set of rules and criterias in the middle of the game. And again, it doesn't require the judge, if he has any problems or concerns or unsure, then, you know, he doesn't have to do this. So it just gives the court some flexibility there. Okay.
Thank you for bringing this bill as well. That's what the purpose is of this adoption calendar, is to make adoption easier and safer for the children. So thank you for bringing this. Are there any questions? Questions been called? Any objection? Without objection, we will be moving House Bill 854 to civil full. All those in favor say aye. Aye. Those opposed, no. The ayes have it. You move out to civil full.
Thank you all very much.
Thank you. Next, we have number 7, House Bill 464 by Representative Slater.
Motion. Second.
Properly motioned and seconded. You are recognized on 464.
Thank you, Madam Chair and committee members. I can't tell you how
Wait,
excited.
I think you have an amendment.
Oh, I do.
You
I do.
do,
Yes,
you
I do.
do.
That is 004975.
Properly motioned and seconded. All those in favor of putting Amendment 4975 onto House Bill 464, say aye. Aye. Those opposed, no. The ayes have it. You are recognized on 464 as amended.
There we go. Thank you, Madam Chair. Sorry to get ahead of myself, but I am very excited to stand before this committee on these very important issues. I have 3 bills, and I think that each one of them will make the path to adoption much smoother. My wife and I are very fortunate to have 7 grandchildren. I won't tell you about all of them, but I will mention to you 2 of them that we picked up this past weekend, and they're with us at our home this week. And both of them came to our family, to our oldest son and his wife, through adoption. And it was an arduous process. It was 2 different processes. Took longer than I think that it probably should have, but God's favor and His grace put those 2 children in our home. Last evening when I got home, I went in to kiss our granddaughter goodnight, and she was still awake. And after I kissed her goodnight, she said, "Grandpa, kiss me again." And so we are so thankful to have him in our home. And then our grandson went into his room, and he wasn't asleep either. And he said, "Will you say your prayers with me?" I said, "Didn't Grandma already do that?" He said, "No." And so I got to say prayers with him as well. So this is very personal, as it is to probably many in this room. And so I'm very happy to present this bill. This bill, 464, as amended, will offer an additional option when it comes to a voluntary surrender. Item number 1 on the calendar today, just a few moments ago, this committee voted to allow virtual surrenders, and this would add an additional option when it comes to that. This allows a voluntary surrender of a child to happen outside of a court. It creates an additional pathway for parents who make the incredibly difficult and brave decision to voluntarily surrender their child for adoption. There are safeguards in place to make sure that even though that this is outside of a courtroom, that it's done in a safe manner for the child, for the birth parents as well, and then, of course, for the adoptive parents. In order for this extrajudicial surrender to take place, it would require the following. It would require the following signatures. The signatures of both parent or parents, birth parents or parents, the birth parent's attorney, which of course the birth parents are already entitled to have under current law. Also, an adult witness of the birth parent's choice with some guidelines around who that cannot be, and also a notary public to verify everyone who is there is who that they say they are. So this bill provides an opportunity, an additional option for voluntary surrender outside of a courtroom. The reason that that's important is because it will can speed up the opportunity for the parent. For example, it doesn't change, by the way, it won't change the required waiting period, but it could take place without having to go to court. And with that, I stand ready for questions.
Okay, now we have a witness that wants to testify, so we're going to go ahead and go out of session and call him up. We're out of session. Jeremy, if you could come up and state your name and who you're with, please.
Jeremy Harrell, Adoption Project. Representative Sorry, Representative Slater. On. How about now? Is that right? Okay. Sorry. Jeremy Harrell, Adoption Project. Representative Slater did such a great job explaining the bill. I really should just say I approve that message and move on. I'll just reinforce a few key points. First, what we're talking about here happens every week in Tennessee for children born in Tennessee. The only difference here is that those children are adopted by parents who live in another state. It's not an option for adoptive parents who live here adopting a child born here. Second, what we talked and we talked about this a little bit a few weeks ago, it puts prospective adoptive parents who live in Tennessee on a more even playing field with the prospective adoptive parents in other states to adopt children born in Tennessee. This option would make it easier for Tennessees to adopt those children born here. Third, it provides safe and ethical options for parents who might be uncomfortable in court for whatever reason and helps preserve their dignity in those situations. It also preserves guardianship being granted by a judge after the surrender is made. So the guardianship would still be granted by a judge. It contains the strongest protections in the country where extrajudicial surrenders are allowed, which is roughly half of the states. And lastly, just to recognize the first bill, the administration bill that passed, it recognizes the intent of that bill and what the committee just did, and keeps any surrender that is done before the birth of a child in a courtroom with the judge. You couldn't. This option would not apply to any surrender that occurs before the birth of a child. Thank you.
You had a few seconds left. How's that?
All right.
You took could you stick around for a few questions, please? You're recognized, Representative Garrett.
Thank you, Madam Chair. Thank you for your testimony. I'm just trying to, I haven't been fully updated on this particular legislation. I'm curious, it always makes me nervous when we take the court out of something so paramount in this regard. So my understanding is that under a voluntary surrender, at that particular time, there's no judge that looks at that. There's no petition. There's no hearing to determine the rights of everyone to approve this particular voluntary surrender. Is that your understanding?
Not at the surrender point.
That's right. That's what I mean.
At the follow-up point.
There's a follow-up one that establishes a guardianship, I believe, for up to 6 months or 3 months.
What? I'm sorry. Oh, sorry. The guardianship would gets granted pretty immediately after. So we actually do allow an extrajudicial surrender in this state if you are in jail. Right. So if you're in a prison, you can surrender without a judge with the warden of the prison, and so it would follow a similar process to what happens in that case.
Okay.
Representative McCarrick.
Thank you, Madam Chair. So, can you describe what, without this legislation regarding the surrender, what happens now?
Mr. Hare.
In the current status, okay, so now you wait 3 days. The child is born. There's a 3-day waiting period. And then presuming you can schedule a surrender hearing with the court, you go to court, you execute your surrender. And then at that point, the guardianship gets granted to either the agency or to the family, depending on the pathway that you're taking. And then from there, you go through the final, the adoption finalization period, which is 6 months. Now, the first bill that we talked about, that shrinks the waiting period to 48 hours, and it also allows an adoption to be finalized in 3 months. Right, so some of those periods change. This, nothing that we've talked about, at least in this committee so far, changes the revocation period on the back end, which still occurs.
Okay.
Representative Garrett.
Thank you, Madam Chair. So this legislation gets rid of the petition at the very beginning once the baby is born.
It gets rid
Mr.
of
Hare.
this. I'm sorry.
It's okay, that happens.
Yeah. Well, it creates an option in which you would not have to go to court to file the surrender paper with the judge. If you wanted to go to court, that it doesn't remove the court if that's the pathway that you choose to take.
Mr. Garrett.
And then one final, thank you, Madam Chair. So I would assume the purpose of this is to shorten that time frame to get to the final adoption, right? That first hearing. So
Yes.
my concern with that is that there's nobody looking at it until it gets to the judiciary's role in granting the guardianship. There's not a judge looking at this at all until that point, and that's where I have some concerns about this.
Mr. Hare.
Sorry. It's the point, a couple of things. One, if you are an adoptive parent, prospective adoptive parent, right, and working with a birth parent who wants to make a surrender that's voluntary. Some situations, there are times when it takes weeks to schedule that hearing, depending on where you are. In some situations, birth parent finds out, oh, I have to go to court. Well, maybe I have an outstanding warrant. That's not stereotyping people who make placements, but there are various reasons somebody might not be comfortable going to a courtroom or going before a judge to do that. And in those situations, what sometimes happens is we voluntarily, involuntarily terminate someone's rights, right? Which then further extends that process because you go through the termination process to get that done. And so from that perspective, that's how you talk about shortening that timeline and giving some options. And I hope I'm answering your question. I apologize if I'm not. The other point, though, is this happens right now in this state, except that child gets adopted by a family in Georgia or Florida or Utah or Arizona or North Carolina instead of being adopted by a family in Tennessee. And when we can keep those families closer, give more of an opportunity to build that relationship. I think I mentioned earlier, we have an open relationship with our daughter's birth mom. That's a heck of a lot easier to do between here and Southeast Tennessee than it is between here and Florida, you know, and the commonly accepted practice, best practice in adoption at this point, didn't used to be 40 years ago, but at this point is the concept of open adoption when it can be done safely and ethically and you can maintain the right boundaries in that relationship. That's what we have. Sometimes people don't want to do that. Sometimes the birth parent isn't interested in it, and sometimes it's not safe. But when it can be, that's the best practice. So the closer in proximity we keep those families who want to exercise that option, the better relationship they can have and the easier it is to build it.
Representative Garrett.
In I've done very few adoptions in my legal career. They've been a step-parent adoption, so there's not these types of issues that come up when DCS is involved, et cetera. In the divorce world, if parties that are divorcing have an agreement, they can have an marital dissolution agreement, a permanent parenting plan presented to the judge, affirm that everything in it is fair and equitable, that the permanent parenting plan is in the best interest of the children. Would you consider this to be a negative aspect? Again, I don't want to slow things down, but if there is a procedure similar to that the judge at the beginning can approve this, where it's not necessarily a hearing or a contested hearing, but it's something that he approves based upon what the surrender is at the very beginning, rather than kind of towards the middle of it, when we're going to establish this guardianship for a period of 3 or 6 months. That's my concern with the legislation, is there's no one at the beginning looking at this as it begins. And they need to be. So if it doesn't move, I don't believe I can support the legislation in its current form without that approval process being at the beginning, rather than sort of towards the end.
Mr. Hare.
sorry, I want to make sure I understand what you're saying. So the guardianship gets granted pretty quickly. In a case, the guardianship, I may have misunderstood what you said. Guardianship doesn't get granted at 3 months. The guardianship gets granted pretty immediately, right? The surrender gets executed. You wait in court. Like currently, surrender gets executed, guardianship gets granted. There's a 3-day waiting period for revocation. In this case, the surrender gets granted. You would file that paperwork with the court and go ahead and get the guardianship granted. You wouldn't really delay the process more than a day or a couple of days. Not a long. I'm not sure that I've answered the question. Did I understand it correctly?
Well, and I may not be asking it very well, but I'm not clear on that procedure, so I've got some concerns about it. So thank you, Madam Chairman.
Representative Powell, you're recognized.
So I had a specific question about, because you keep referencing, it's been referenced, the out-of-state, adoption process. Yeah. So is that, and pardon me for trying to fully understand this, that is taking place in that process in those states, and it's not taking place in Tennessee? And if you could clarify that.
Mr. Hare, you're recognized.
So, two things. It can go both ways. A child, what I'm referring to is a child is born in Tennessee. The adoptive parents live in another state.
Okay.
That surrender is actually executed in Tennessee. They don't leave the state. Then there's an ICPC process for any adoption that crosses state lines, anything like that. But the surrender is executed here in accordance with Florida's law, because Florida's law, and our law says the same thing, that a surrender executed in another state in accordance with that state's law or with this state's law is valid for an adoption in our state. When you read in various sections of the code, it says except for adoptions executed under subsection G. Right? Well, subsection G is what says if a surrender occurs, a surrender is valid that's executed in another state under the laws of that state, or currently, because we require a judicial surrender before a judge, right, in accordance with our state's law. Those states have the same law, right? So it would say, Florida's law would say, for example, surrender executed in accordance with that state's law or with Florida's law. It's valid for an adoption to be finalized there. So the child's born here, surrendered under Florida's law here, adoption's finalized in Florida because the child is surrendered under Florida's law, and that's valid.
Representative Powell?
No, I appreciate you walking me through that, and I understand that clarification. I'm just curious as to why it is done that way, but I guess I get the premise, but I'm not sure why we would be allowing that surrender to happen under that other state's jurisdiction under there. So that's something I'm kind of struggling with, and I get it's happening in other states, but sometimes I'm cautious just because it's happening in other states doesn't mean that's best for Tennessee. But it is creating an unfair obstacle for Tennesseans. But I'm just I appreciate your explanation of that, but I'm not sure why that is done that way.
Mr. Hare?
It's actually really common across, it's like reciprocal agreements, right? It's pretty common across states. There are a handful of states that have more regulations around that, not many, and they usually are not considered very friendly toward adoption in states that do that. It's, again, we can have another discussion about if you're crossing state lines, that is there a federal component to that beyond ICPC? Perhaps there should be, but there isn't. But that's why that happens.
Chairman Farmer?
Yeah, and thank you. I may ask just first if we go out of session. I was going to ask Ms. Sonia to help Representative Powell and others understand how those interstate compacts work. If you could we do that, or is that beyond that's way outside the scope, I know, of today's bills, but I thought it's important for us to understand that. Said it is.
Without objection, we'll go out of session. Sonia, you're recognized.
Elizabeth and Sonia, Legal Services. When children are taken across state lines, there is an international compact regarding how that can be done. There are a lot of requirements and it's to ensure that there's not, trafficking situations, but without getting into the specifics of what those requirements are right now, but there is at least in existence.
Any other questions for legal?
No. Thank you. I do have,
Seeing none, we'll go back into session.
do have a couple for our speaker.
You're recognized.
Yeah, and I think also, sir, if you could explain a little more about this surrender process, right? What are you trying to do now? What are the safeguards in place? Because I think Representative Garrett's concerns, and maybe another member or two concerns, what are our safeguards in this surrender process compared to the current surrender process that's in place? So if we could talk about that just for a minute, it'd be great.
Mr. Harrell.
Thank
you're
you.
recognized.
So currently, you go to court, right? So there's a judge. You are entitled to an attorney. You do not necessarily have to use that attorney, right? But you are entitled to one under the current statute. You would remain entitled to one, and in this case, you would surrender, again, after the waiting period, with the attorney who represents you, the birth parent, represents the birth parent, who you are also entitled to. You would also that would also include a witness of your choice. That witness cannot be a family member of the birth parent within certain level of connection, or the prospective adoptive parent, cannot be the other birth parent, cannot be the prospective adoptive parents themselves. The way this is written, you could not be a representative or an employee of an adoption agency who has some financial interest in the matter, with the exception of, and I was asked to put this in, the counselor who is specifically counseling for the birth parent. Right, they are there to help them understand what they're going through and explain their rights. And then a notary public who would just verify that all these things, all the folks who are involved are who they say there are. Typically, when I say this is the strongest protection anywhere, I mean that very literally. It is typically one or two adult witnesses is how the statute is written. Occasionally, it will also require a notary as part of that. But in this case, you have to be represented by an attorney. That is your attorney who represents you. You are already entitled to that. It is a witness of your choice who cannot have some interest in this action, right? And a notary making sure the people who are there are who they say they are.
Chairman Farman.
Yeah, and thank you. And so, in this surrender process, is that when does the child physically go with another family? Is that what this surrender process, or is this process saying, hey, you know what, we are going to surrender this child for the opportunity to be adopted, and then at that point in time, the child then goes with the adoptive parents? How is that? I'm just trying to, because I haven't practiced this area of law either, and I'm trying to understand exactly what. So the surrender process is at that point in time the child goes with the new adoptive parents, or is surrender mean, okay, look, I'm opening ourselves up to our child that may be born or is born to move forward with birth parents, with a guardian, with all the other safeguards from that point forward as well, right? How does that work?
Mr. Harrell.
So it can happen a variety of ways right now. If the child is born, once the child is born, there's a 3-day waiting period. Currently, again, just got in a previous bill would reduce to 48 hours. When a child is born, there are a couple of options at that point, right? The child can leave the hospital under an adoption agreement with the prospective adoptive family who's home studied. I mean, that all remains in the law. The child may leave the hospital with for lack of a better term, in the custody of the adoption agency, and be placed with a respite family for a period of time, depending on the comfort level of the adoptive family, right? Some people might not be comfortable with taking a baby home before the surrender is executed. The surrender then gets executed later, 3 days after the child's born, currently. At that point, the same thing remains. The child could go home with the adoptive family from there, could have already been with the adoptive family, could have been with a respite family and go home from there, could go home from there with the adoptive family, or could remain with a respite family until the 3-day revocation period is over, right? So it's a big pathway here, and and frankly, the birth parent has some voice in that too. The birth parent could say, I'd rather the child go to a respite family in the first gap, in that 3-day gap, the first 3-day gap. So there are a lot of different pathways to get the child to the house, to the prospective adoptive family, or into a respite family, if that's, I'll use us as an example. So with our oldest daughter, when her surrender was, she went home from the hospital actually with her birth mom, and her birth mom went through a process, made her decision. We had not actually met before she was born, right? And so that was a little different situation. She decided to make an adoption plan after our first daughter was born. Once she made that decision, we met. She then surrendered the child. She surrendered our daughter. When she made that surrender, for a variety of reasons, we were not yet comfortable with her taking a child into our, we had an 8-year-old at the time, too. He's now almost 11, but so we just weren't comfortable with the risk associated with that. So she was with a respite family for 3 days, and when the revocation period ran out, that's when we accepted the surrender, and she came to us at that point. That was through an agency. With our youngest daughter, because we had been through it before, she came home from the hospital with us. That was a Sunday. The surrender occurred on a Tuesday. The revocation period ran out on Friday. And so it's a variety of different pathways.
All right, and I think you've answered my question. I guess what I was getting to is by passing this bill, I'm trying to see what safeguards would be taken away, and I don't think there are any, because all those other waiting periods are still in place. Mm-hmm. We're just talking about the surrender period, which sounds like can go at least 5 different ways from what the example you just gave, right? So it may provide some consistency and some reasoning for I'm just trying to see what would be wrong with this. I'm not picking up on a lot of red flags on the surrender portion. I'm just not. So I appreciate your time, and I'm not going to take any more of the committee's time. Thank you.
I think it's Mr. Harrell.
If I could just add one more thing I'd really like to understand the front end piece and how we can make that better. This is Representative Slater's bill, but I can't imagine that we wouldn't be willing to have a conversation about how to make that stronger.
Representative Garrett.
Thank you, Madam Chair. I do think it's worth having more conversation on this because I'm not comfortable with it currently, how it's currently been presented. I have some issues with how, terminating someone's parental rights is a huge issue, and we're making it. I get that we want that child to be placed, and for you that have been, and Representative Slater that has been an adoptive parent or an adoptive grandparent, I get that. But I'm also concerned about, is fast tracking the best way to place a child, whether it's done in an hour, or should it take a little bit longer? And I'm worried that we are working down legislation that we're going to be doing this like we're going through a drive-through at McDonald's. And I'm very concerned that there's no reason to do that fast. And so I'm just a little bit concerned that we maybe haven't vetted out everything that we need to vet out to make sure that that the birth mother is completely apprised of the situation, and a judge can make sure that she, and if the father's involved, that's aware of what they're giving up. And that's my concern here. And I don't want to put that above a prospective adoptive parents over that a parent understands what they're giving up. That should be paramount before we make an adoptive parent's abilities to make it fast-tracked. And so that's my concern with where we are right now. So,
You good, Mr.
Certainly not the intention to be a McDonald's drive-thru. Actually very opposed to anything that would look like that. And essentially the same attestation that the judge is currently required to give, the attorney is required to attest to here. That's what their attorney is for. It's in the surrender form, and the language is essentially the same between what the judge is required to attest to and what the attorney is required to provide for them. I understand.
Representative Garrett.
we've got one attorney here for the surrendering party and one attorney for the birth parent. I've got a problem with that as well.
Sure.
Is that we've got also that the birth parent or the prospective adoptive parents are paying for the attorney's fees for both sides. So I get that, but again, we've got to be careful on what lane we're going here and how fast we're going. And so I've just got some issues.
I would like to add this to it. A baby has had the mother's heartbeat the whole 9 months, listen to it. So it's really important that that child gets with the new heartbeat of the new mother to bond as soon as possible. So that's a thing to think about too. So when the more days it's away from its mom and the new mother, it's missing out on the bonding. Because that baby has had that same heartbeat for 9 months and it doesn't know what to do without it. So that's just my 2 cents worth. So, Chairman Farmer.
And just to follow up on a couple of things, in your experience, there may be some concern, well, the adoptive parents are paying for X, Y, and Z. Well, is that because both parties agree and want this to happen? Because I think the concern is, well, we have people with money that may be coercing this mother to give up this child, and I've heard the term termination. I don't think this is a termination issue. This is an issue by agreement. And we have a mother that may not be in a financial position to pay $10,000 for a lawyer to appear in court 2 times for him, to allow this to happen, to allow this child to end up with people who can care for them financially for whatever reason. Maybe this mother wants to care for this child, just young and just not ready yet.
Right.
You know, and that's probably most of the case. But what are the safeguards there with regard surrounding just kind of? I know I just threw a lot at you there, but I think those are some of the concerns that the committee have. But I see this more of an agreement issue, not a termination issue. And I know that the adoptive parents typically pay. Well, that's because of just certain things that happen that's beyond a young mother, potential mother's control, right? So if you could just speak to that. I know it's kind of open-ended, but
Mr. Harrell.
Thank you. There are a couple things in there. The statute is what says that. Like we did it. We paid for our girl's birth mom's attorney in our adoption because the statute. I mean, I would have done it anyway if she needed an attorney. The statute requires that. My contact with them was, here's the contract. We're representing her. We're not representing you. I mailed them the payment, and they represented her, in that they went to court with her. I did not go to court with her. Like that's who they represented. Like that, and so that's the safeguard protection. They're under the rules of the court here. Right? That's what that contract is I'm only paying for a representative for the birth parent, and then I don't communicate with them. At that point, there was another piece, and I've skipped it.
Chairman Farmer.
so you've touched. So statutorily, the adoptive parents are required to pay for what?
Required to pay. The birth parents are entitled to an attorney at our expense to represent them.
And that's
Chairman Farmer.
That's today.
So that's currently in statute.
That's today.
And I guess my next concern or my next question for you was, well, how do we know that birth parents aren't being persuaded by these potential adoptive parents? What are the safeguards there currently now and in this bill? And does anything change?
So they're not a party to the surrender. The birth parents are not. I mean, the adoptive parents are not a party to the surrender. It maintains the current statute on the representation. In fact, they're explicitly prohibited from being a party to the surrender along with their family or the adoption agency, again, except for the person who is specifically assigned to counsel the birth parent, because that might be who they're comfortable with. It also, again, what you don't get in some other places does here by limiting the ability to be a family member of the adoptive family. I mean, the adoptive family certainly, but the birth family. What you prohibit there is a parent or a sibling or something like that from being able to pressure being able to pressure them to do that.
Chairman Farmer.
All right, last question is this. What judicial safeguard is in place in this bill?
It
Mr. Harrell.
Sorry, it maintains the guardianship, which again comes pretty quickly, right after the surrender, the guardianship takes place. It's not a judicial safeguard, but it is a forward-looking safeguard. These are all home-studied families that have, so just from a safety perspective, judicial safeguard in the guardianship, and then also the adoption itself is finalized in court under the laws in the statute that, we just addressed some birth parent expenses in a previous bill, and some counseling-related items, but all of those things that exist in the statute now, as that adoption moves through the process and get finalized, they are all there.
Right. And that's what I'm thinking. I just was afraid that I didn't want us to get hung up on the surrender process, because if I'm looking at it from a 10,000-foot view, looks like a very small portion. We have the guardianship. We do have judicial discretion intervention in the end for the adoption, and that court's going to hear all the testimony and before the court makes that recommendation. So I don't see any talked about financial coercion. Don't see that there, because the birth parent and the adoptive parents aren't involved. There's an intermediary there. The surrender process, trying to expedite that, because right now it can go 3 or 4 ways. There's a guardian appointed. It ends up in front of a judge before the final adjudication happens. So there is a judge involved. The court doesn't lose discretion on this. We're just trying to expedite things on the front end. That's what I see this legislation doing. If you disagree with me, let me know. Otherwise, I'm going to not take any more of the committee's time.
Mr. Harrell.
I do not disagree with that, and would add that any expenses that get paid, including the legal fees, those all have to be disclosed on the form as the adoption moves through and is finalized.
Any other questions for Mr. Harrell? Seeing none, we're going to go back into session. Thank you very much for being here. We're back in session.
Question on the bill.
Question's been called. Is there any objection? Seeing none, are we ready to vote? All those in favor of sending 464 out to civil full as amended, say aye. Aye. Those opposed, no. No. The ayes have it. The bill moves out to full.
Thank you, Madam Chair. Thank you, committee.
If you want to be recognized as a no, see the clerk. It's done. Okay. Next bill is number 8, 464, by Representative Slater.
Thank you, and there
Properly motioned and second.
there is an amendment on the bill that rewrites the bill.
Is that 3762?
That is correct, 3762.
Do we get a motion? Motion and second on the. I did. I was going to get a second or first. You're good. You're good. There we go. So, you ready to put that on the bill? Does it make the bill?
Yes,
Okay.
Yes,
So
it does.
we're going to put all those in favor of amending 461 with 3762, say aye. Aye. Those opposed, no. It's on the bill, so you are recognized on 461 as amended.
Thank you, Madam Chair. Thank you, members of the committee. This bill is a brief bill, and it is a bill that has to do with grounds for termination of parental rights. And any time that I would look at that, I would first of all be thankful. I'm thankful for the fact that Tennessee stands for parental rights. And so it's with great sobriety that I would come and adjust that in any way. But this does go to grounds for termination of parental rights. The bill is, I think, simple to understand, and so I'm just going to simply read the amended bill. This would be grounds to terminate, so it would not be automatic termination of parental rights. This would be something that the judge or the chancellor would consider as grounds to terminate parental rights when the parent has been confined in a correctional or detention facility of any type by order of the court as a result of one or more criminal acts under a sentence of 6 or more years, and the child is under 8 years of age at the time the sentence is entered by the court. And so with that, I stand ready for any questions.
Are there any questions for Representative Slater? Representative Bricken, you're recognized.
Just curious on the 6 years, kind of where did it might have come from? And is any feel for how many, I guess, terminations this would expedite in Tennessee?
Representative Slater.
Yes, thank you, Madam Chair. First of all, currently it is 10 years. If you're facing 10 years, this would reduce it to 6. The reason that I went to 6 years is because at age 14, when it comes to what is best for the child at 14 years of age, so 6 plus 18 being 14, the child then has a say in that matter. So that's how I came to the 6 years, because the child is going to be involved in that process as well at that point.
Thank you.
Representative Bricken. Anything else? Any other questions for Representative Slater? Seeing none, are we ready to vote? All those in favor of 461 going out to full civil justice as amended, say aye. Aye. Those opposed, no. The ayes have it. You move out to full.
Thank you, Madam Chair. Thank you, committee.
I think you have one more.
That is correct.
This is Mr. Slater Day. Next is number 9, House Bill 460. Representative Slater, you're recognized.
Thank you, Madam Chair.
Motion? Second? Your properly motion and second?
Thank you, Madam Chair. And there is an amendment that doesn't completely rewrite the bill, but the amendment will make it much easier to present it. It'll get rather confusing if we don't attach the amendment.
Is that 4852? Is that what you have?
And that is correct, 4852.
Okay. Do you hear a motion? Motion. Properly motioned and seconded. All those in favor of putting Amendment 4852 onto House Bill 460, say aye. Aye. Those opposed, no. The ayes have it. You are recognized on 460 as amended.
Thank you, Madam Chair. Thank you, committee members. This bill as well has to do with grounds for terminating parental rights. Currently in statute, severe child abuse is one of the grounds for terminating parental rights. And currently in statute, there are several offenses that define what severe child abuse is. This bill would add to those current offenses the definition of severe child abuse. And I'll share those, read those to you. There are 8 that would be added to the definition of severe child abuse: sexual battery, aggravated statutory rape, continuous sexual abuse of a child, solicitation of a minor, soliciting sexual exploitation of a minor, promoting travel for prostitution, especially aggravated rape, and especially aggravated rape of a child. So those 8 offenses that are already current in Title 39 would be added to the definition of severe child abuse. And with that, I stand ready for questions.
Thank you very much for bringing this bill. These are very heinous crimes towards a child or toward anyone, so thank you for bringing this. Are there any questions? Representative Powell, you're recognized.
Just a question on the amendment. So why did you delete those other things that were in the original bill?
Representative Slater.
Yes, in consultation with the Tennessee Bar Association, and then there were also some concerns that were raised by some in the judiciary. It was best to go ahead and remove those, and it made the bill better.
Okay.
Representative Powell.
I was going to say, I appreciate you doing that. I know one that stood out to me was indecent exposure, which I take very seriously, but I know that's a problem for a lot of people that are experiencing homelessness. Could be found guilty of indecent exposure because of their situation. I just want to say I hadn't seen the amendment until you introduced it, so I think it makes the bill better. So thank you.
Thank you.
Any other questions? Representative Bricken?
Thank you, Madam Chairman. I was trying to figure out the fiscal note on this bill. I mean, this does not change laws for conviction of these issues. So I'm not sure why the fiscal note says DCS has to investigate them, because they would be already tried by the court. So can you help me out there?
Representative Slater?
Representative Brickman, I am trying to figure out the fiscal note as well, because I was surprised at the amount of the fiscal note. And so I've looked at it, and I'm trying to determine why that fiscal note would be so high. The fiscal note, in reading the explanation of the fiscal note, it's been opined that it will require more DCS investigators in order to do this. But like you, I'm scratching my head as well.
Thank you. All right.
Maybe that's something we can work on. We'll see what we can do, because it is a very good bill. Are there any other questions for Representative Slater? Questions been called? Any objection? Hearing none, are we ready to vote on House Bill 460 as amended, going out to full civil? All those in favor say aye. Aye. Those opposed, no. The ayes have it. You move out.
Thank you, Madam Chair. Thank you, committee
Thank you for
members.
being with us today. So next we have number 10, House Bill 163 by Representative Butler.
Thank you, committee and chairman. This bill takes the current...
Properly motion and second. You're
Sorry.
recognized.
This bill takes the current statute and makes a little bit of tweak to it. So currently under the statute, there's a 120-day period that has to occur for a child to be considered abandoned. And so this bill simply reduces that to 90 days for children under the age of 4. And that's all this bill does, is just take the 120 days down to 90 for children under the age of 4. And with that, I'll renew my motion and answer any questions.
Are there any questions? Representative Butler? Here none. We ready to vote? All those in favor of House Bill 163 moving out to civil full, say aye. Aye. Those opposed, no. The ayes have it. Moves out to civil full. Next up, we have number 11, House Bill 164 by Representative Butler. Properly motioned and seconded. You're recognized, Representative Butler.
Thank you, committee. So I'm going to probably give you a little information you may or may not be aware of, but under current law, there's what they call the safe haven law. And the safe haven law allows a mother to drop off a child at a safe haven location, which is a fire department, a place manned 24 hours, a hospital, etc. And so currently under the current legislation that's been passed for safe haven, which I think is a great bill or great legislation, that child is then taken to a hospital to be checked out. And as long as that child is not harmed in any way, not drug addicted, not abused, etc., then the mother can return and retrieve that child within 30 days with no questions asked. Statistics show us that 94% of the time, the mother never returns. So that child is abandoned at that point. So under the current law, that child will then go to the custody of DCS. This bill directs DCS to transfer the physical custody of the child to a nonprofit adoption agency, so that the nonprofit adoption agency would then handle things from there. And so currently under current statute, what we've done is pull some of these timelines and use those to strengthen this bill. So currently under current law, there is a 90-day period that must occur for the termination of both the mother and the father's rights. So that's 90 days. At 180 days, current adoption law requires for the physical custody to be in the potential adoptive family for 180 days. So we're taking the current statutes and utilizing those to take this child that was abandoned, and 180 or 181 days later, for the family that's been caring for this child to have adopted that family and streamline this process. Now, unfortunately, currently DCS transfers the average child 3 times the first year that DCS has custody. And yesterday, a good friend of mine was our chaplain of the day, and his daughter is a prime example of why this type of legislation will help put more children into homes faster and break the cycle. So I'm going to share just a little bit, if you'll indulge me just a moment. Michaela, who I mentioned yesterday, who is a nurse right now, she was adopted out of a horrible situation. She had 10 other siblings, 2 of which didn't survive the abuse they endured. Out of the remaining siblings, she is the only one that was adopted, the only one that did not have that graduated college, the only child out of those 9 that actually went on to graduate high school, did not get pregnant out of wedlock, did not get pregnant in high school. I think out of the 9 children, including her, 4 of those were girls. 3 of those girls had children before they graduated high school. So my point in saying all that is, it works. If we can get these children out of the system immediately, get them into stable homes, they will be successful, and we can break the cycle. And so with that, I will renew my motion and be glad to answer any questions.
First, we're going to go to a session because we have some witnesses that want to testify. So without objection, we're going out of session. And Reverend Mark Hodge, if you would come forward, please, and introduce yourself and who you're with for the record, please. Wherever you want to go, it's fine.
Make sure your red button's on.
Thank you for being here today.
It's my honor. I appreciate that. Now, we practiced for 3 minutes. I'm going to try to go down to 2, so I'll talk real fast. And hopefully there'll be some questions to help me get a little extra time. But anyway, Reverend Mark Hodge, I am here not as an expert, but as just a person of experience. My wife and I, we have 3 biological children, 8 grandbabies, hallelujah. We also have 6 adopted children. 5 of those are from foster care. 2 of those babies have passed away. You'll hear more about Christian a little later. We also currently have 5 level 3 foster sons. We are a resource treatment home. So we've experienced a lot of foster care and adoption. So I know this is about safe haven, and I've heard the terms fast tracking, and there are ways we need to kind of speed this up. I want to talk more about the foster care adoption end of this. Because from our experience, there's very little protection or help on the foster care adoption end of things. There's a lot of support and help that goes towards the biological family. So not only have my wife and I done this since 2012, and we've had people in our home even before that, but children and stuff. But my daughter and her husband, they're now 2nd generation foster care and adoptive parents. They have 1 young son. They're working on getting adopted, and the TPRCS just drags on and on and on, one thing after another, and more court dates. But the main reason here, and I also have a letter, I don't know proper protocol from my experience, I have a letter that she read during a CFTM meeting when she was getting ready to have to prepare herself to surrender her son that she had had for 1 month, a little over a month. I want to talk about him, Levi, real quick. They got a call, and a baby was abandoned at the hospital. So within a matter of 2 hours, they had already arranged to go to pick up their son, stay the night with their son. They actually got to name their baby boy. His name's Levi. They spent the night, brought him home the next day. And when DCS called them, this was a 100% done deal, safe haven baby. Adoption is no doubt about it, and come get him. And they said, we'll be there. So they did all of that. And then about a month later, right about a month, 4 weeks, 3.5, 4 weeks into that, then there was a dad.
Sorry, sir, your time is up.
Well, that was fast. Okay,
No,
sorry.
Are there any questions for Reverend Hodge? Seeing none, thank you very much, and God bless you
All right,
for.
thank you. Is there any way to give the letter out to the council? That I could just present that, or?
You can email it to her or to my office, and I'll get it to her, and she can send it out to the
Thank you so much.
committee. Yes, and thank you. God bless you. So next, we have DCS wants to speak. If y'all would come forward and introduce yourselves and who you're with for the record, please.
Thank you, Chair Lady and committee members. My name is Jim Lehman. I'm the Legislative Director for the Department of Children's Services, and I have with me Sammy Mayfair, who's our Deputy General Counsel. First of all, I just want to say that our position on this legislation is working with sponsor, and I want to thank the sponsor for meeting with us several times recently to discuss the concerns of the department with this bill. I also want to say that Section 2 of the bill, we have no concerns with. Section 2 speeds up some of the timelines for safe haven babies and getting them adopted and that kind of thing. We have no concerns with that part. It's Section 1 that we have some concerns with, and those relate to removing the sole placement authority of the department for these babies. I would say, in general, that it's a very small number of children that we're dealing with a year, and that it's 5 to 10 usually of these safe haven babies, and that we are able to place these children. These are brand new newborns, and we do not have any issues with getting them placed and in good homes and that kind of thing. But I will let our Deputy General Counsel share a couple other concerns.
Yes, good afternoon. Sammy Mayfair, Deputy General Counsel, Department of Children's Services. The concerns that we have is that, as Mr. Lehman mentioned, that this would potentially violate TCA 371129C, which gives the department sole placement authority for children in its legal custody. We are required under the federal law as well to maintain sole placement authority for children to be 4E eligible. So this would, in essence, put a child in our custody, but then direct us where we have to place that child. If that occurs, these children, throughout the entirety of the time that they are either in the custody of the department or once they are adopted, would not be 4E eligible. This does impact the resources that would be available to the prospective adoptive parents. The entire custodial episode would be state funded. The time that the child would be eligible for adoption assistance would be state funded, which would also reduce the time that the child would be eligible for adoption assistance. Under state funded adoption assistance, that's only available through the time that the child is 19, whereas if the maximum eligibility for 4E adoption assistance is 21. This would also impact the insurance for the child. Again, if the child is not 4E eligible, if the prospective adoptive parent, or at that point adoptive parent, moves to another state, they would not automatically be eligible under that state's Medicaid. They could maintain TennCare while they are here, but they would not be eligible potentially for Medicaid in the other state. And so while we are talking about a small population of children, it would substantially impact the services available to those children if we restrict the department's placement authority.
Thank you. We're going to go right into questions because we're running out of time. We have to give up the room at 1:30. Representative Powell.
If you could, one part of the bill I'm interested in is if you could speak to the sort of regulations and I guess oversight you place on these nonprofit licensed child placing agencies.
Ms. Mayfair.
Yes, thank you. So we do license, the Department of Children's Services licenses the child placing agencies in Tennessee. And so presumably any licensed nonprofit child placing agency as contemplated by this bill would be subject to the department's licensing regulations. And so that includes, we have a set of rules that they have to adhere to. It's licensing visits, it's file reviews, it's things of that nature to make sure that they are operating as anticipated by the Tennessee licensing standards.
Representative Powell.
And do you, under this, would you be given any further authority to go in and see how that placement is working, that adoption, or not adoption, but that placement is working in this situation?
Ms. Mayfair.
Thank you. The child would still be in our legal custody, but would be mandated to be placed with this agency. So I would anticipate that we would still be required to provide the same oversight to any other child in our legal custody if we had voluntarily placed a child in an agency home, for example, because we do have agency homes that support foster children currently, and we do that through contracted providers, and so we do have oversight with that.
Representative Powell.
So would this, I guess my question is, at the end, would this create more work, if you will, for the department to then go in and look at these individual situations and cases?
You're recognized.
Thank you. No, I don't believe that it's an issue of additional work. Our concern is just focused primarily on the fact that it would mandate placement with one specific entity.
Any other questions? Representative Garrett, you're recognized.
I know we're coming up close on time, Madam Chair, so thank you. I don't remember the statute you quoted that gave you the right to place, but I would assume that that authority in the statute is not delegable. You cannot delegate that authority whatsoever in the statute.
We have to, both by federal law and then the statute 371129C, the department maintains sole placement authority for children in its custody.
And
Representative Garrett.
Representative Powell has some questions about, the bill provides a nonprofit to take custody. When you take custody or the state takes custody, do you ever place them with a nonprofit?
Yes.
You're recognized.
Thank you, sorry. I'm sorry. Yes, we do, and the issue is that we make that placement decision to place with them. This bill would maintain this child in our legal custody, but require us to place into this nonprofit.
Representative Garrett.
So this legislation is placing children in a nonprofit and assuming that it would be the same nonprofit that you would put it in. What would be the conflict in federal law or state law that would prevent that placement to happen if it's the same placement that you put them in?
Ms. Mayfair.
And I can't say for certain that we're placing safe haven babies in nonprofit homes right now. They're actually probably our easiest babies to place because it is likely an infant that will be freed for adoption relatively easily. So it's the type of infant that our DCS foster homes would relish the opportunity to have placed in their home. The conflict is, again, the discretionary placement versus the mandatory placement that's the problem.
Okay.
Thank you. Thank you, Madam Chair.
All right. Without objection, we're going to roll this and the rest of the remaining calendar to next week. Without objection, we're going to be adjourned. Adjourned.